I'm Lance Stewart. I'm a partner with Angus and Terry. We're a law firm. We represent homeowners associations. Thanks so much for coming out tonight. And thank you to Tony and Barbara and everyone at AMC for having us tonight. We appreciate the opportunity to speak to everyone. I am a little under the weather, so if you come up and ask me questions afterwards, I'm probably not going to shake your hand. Maybe we can do a little elbow jostle, but I'm a little under the weather, so if I say things that don't make any sense or if I collapse on the floor, don't worry about it. Just throw some water on my face. I'll get back up and keep going. I'm looking back over my notes here. Okay. So tell you a little bit about our firm. Again, our name is Angus and Terry, LLP. We represent homeowners associations. That's all we do. That's all we've ever done as a law firm. We were one of the first law firms in Northern California to exclusively represent homeowners associations. We've been doing that for about 30, 35 years. Represent somewhere in the neighborhood of about 1,000 different community associations. We do work all over California, but also in Ohio and Florida. And really what we do is we try to provide a full service operation. Whatever legal issues your community is dealing with, that's the service we want to provide, whether it's rewriting your governing documents, like we're going to be talking about tonight. The board needs some guidance on what they can and can't do. You've got a homeowner dispute. You've got a vendor contract you need help with. You've got something that's shaking up into turning into a lawsuit. All of that we treat as sort of our general corporate counsel work that we do. We also work on construction defect matters. I don't know if a lot of folks in this room have communities that are under 10 years old. If you do, make sure you're working with our office or somebody on addressing whether you have a construction defect issue to address with your builder. But that's all we do is represent homeowners associations like yours. If you're at a point right now where your HOA needs counsel, you need new counsel, feel free to reach out to us. I'll leave some cards here. I think Ivy and Nick, my good friends in the back, probably have cards too. You can get our information, reach out to us for a proposal. We do offer a special right now where for the first 6 months, you take us on as counsel, we reduce our hourly rates for that period. Because we know we take on a new HOA, a lot of times there are a lot of things that need to be addressed quickly, a lot of legal issues that are sort of burning rubber in your HOA, you need to deal with them quickly. We try to ease the strain of those first few rounds of legal bills by reducing our hourly rates for the first half year. We also provide a complimentary 1-hour board legal training because we know everybody here is a volunteer, right? You're overseeing your HOA basically in your spare time and you're responsible for this multi-million, if not billion-dollar enterprise, where there's huge consequences to the decisions that you make, and you're not always given all the tools you need to make those decisions. So anytime we take on a new HOA, we want to make sure we're giving you guys that 1-hour board legal training to make sure we're all on the same page about how you need to be conducting the HOA's business, sort of the rules of the road for conducting that business, and we can work together most effectively. If you need a proposal, feel free to reach out to me. You have my email address there on the bottom, lstewart@angus-terry.com. Angus pronounced like the beef, but there's an I stuck in the middle there. lstewart@angus-terry.com. And again, we'll have cards for anybody that needs them if you want to reach out for a proposal. And like I say, we do the construction defect work. We had some nice successes with our team this year. Brought in over $50 million for our clients in 2025. If you have an HOA that's under 10 years old and need to be thinking about those issues, please feel free to reach out to us. We do a complimentary site walk with an expert to get a sense of what issues you might be looking at in your community, sit down with you, figure out a game plan for a construction defect claim if that's appropriate for you. And we always work on a contingency basis. You're not paying us to pursue the claim. If we don't succeed, then you don't succeed. We make sure that we get paid out of a portion of the proceeds for your claim, but you're not paying us up front for that work. Okay, and that's my smiling face there. Updating your governing documents, why now is the time to do a complete revision of your association's governing documents. Two things I'll highlight right out of the gate when we're talking about governing documents. Your governing documents for your community, number one, are there to make sure everybody knows what it is they're supposed to be doing. The board, the homeowners, to a lesser extent the tenants, they're there to provide everybody with some understanding of what it is they're supposed to be doing. And number two, your role as board members, your responsibility as board members is to make sure that your governing documents actually say what they need to say to tell everyone what their responsibility is. So we're going to talk about how those things play out. Of course, because I'm a lawyer, I have to give a disclaimer up front. Nothing in this presentation is legal advice. Yes, sir.
This is different than the CC&Rs, right?
Yeah, we're going to go through all of them. We're going to talk about CC&Rs and bylaws and rules, but CC&Rs are going to be a big part of what we talk about, okay? To give you actual legal advice, I would need to look at your particular situation. I would need to look at your governing documents, the facts you're dealing with. This is meant to be general information to sort of point you on the right track, but nothing I say here is meant to be legal advice for your particular situation. If we already represent you, if you need representation, feel free to reach out to us for guidance on whatever issue is you're dealing with. Whether it's about rewriting your governing documents or not, you need help with a legal issue, feel free to reach out to us and we'll give you some help. A big concern we have with anytime we do a presentation is, and we'll touch on this as well, laws change all the time. If I'd given a presentation, June 30th of this year on fine schedules and enforcement policies for HOAs, 2 days later my presentation would have been outdated. So we need to make sure that we're not circulating outdated information. We do the best we can, but part of the reason we have to give this disclaimer is because in 5 minutes some law is going to change and it'll turn out what I said tonight isn't true anymore. And of course, please don't distribute this presentation anywhere. Okay. So back to the gentleman's question here a moment ago, we're going to be talking about a few different pieces of authorities and how they all relate to each other. The beginning piece is the law. That's what governs everything that all of us do. The other pieces are your particular HOA's particular governing documents. Every HOA in the state of California, every homeowner, every board member in the state of California is bound by California law. We typically talk about the Davis-Sterling Common Interest Development Act. That's the one that gets name-checked a lot. That's the one sort of ground zero. That's sort of our basic, biggest tool for HOA California law. We also have parts of the Corporations Code, the Nonprofit Mutual Benefit Corporation Law that's in the Corporations Code. Because HOAs are corporations, they're not representative democracies, they're corporations, they're also governed by that part of the Corporations Code. Fair housing law comes into play, the California Fair Employment and Housing Law, as well as Fair Employment and Housing Act, as well as the Federal Fair Housing Amendments Act. Those apply to HOAs. The California Vehicle Code comes into play. Of course, there's court rulings, things along those lines. When you guys come to us for an opinion, those are the things we're starting with to tell you what it is you can and can't do, what you're not supposed to do, what you are supposed to do. But they also govern everything else we're going to be talking about. That's the starting point. When we get into your particular governing documents is what does the law have to say about what the HOA is supposed to be doing. Your governing documents have 4 basic forms. The first one is the Articles of Incorporation. We don't really spend a lot of time dealing with those usually. The Articles of Incorporation is the document that creates your HOA in the first place. Whenever your development was created by the builder, they filed the Articles of Incorporation with the Secretary of State saying, this corporation now exists, this HOA now exists. It is Riverview HOA, it is Riverview Townhomes HOA, it is Riverview by the Bayside HOA, whatever the name is. The Articles of Incorporation create your HOA. And after that, we don't really often turn to that document. The big ones are the Declaration of Covenants, Conditions, and Restrictions, or what we call the CC&Rs, and the bylaws. And we're going to be spending most of our time this evening talking about those 2 documents. The law can only do so much when it comes to telling individual homeowners and board members what it is they're supposed to be doing in your community. You need these documents, the CC&Rs and the bylaws, to really get into the nuts and bolts and the specifics of what your community needs. The CC&Rs tend to be a lot of the meat and potatoes issues, the substantive issues. We're talking about who's responsible for maintaining what component. Is it the homeowner? Is it the HOA? Who's responsible for having what type of insurance? Is it the homeowner? Is it the HOA? A lot of the terms get defined in the CC&Rs. What makes you a member of the HOA? What's the actual official name of the HOA? What's the property that the HOA consists of? That's in your CC&Rs. What happens if a calamity strikes the HOA and we need to deal with insurance payouts from that calamity? A lot of the sort of everyday issues are in your CC&Rs. They're sort of substantive in nature. The bylaws are more procedural. So if the CC&Rs are talking about the HOA's business, the bylaws tell us how to conduct the HOA's business. What does it look like when the board has a meeting? What does it look like when there's a meeting of the members as opposed to a meeting of the board? How many board members do you have? What's a required quorum of the board so you can actually hold a board meeting and conduct the HOA's business? What does it look like when we're holding a membership vote? All the tools that you need to actually conduct the HOA's business, those are going to be in the bylaws, the process for how you do those things. Now, like I say, we're going to spend most of our time talking about the CC&Rs and the bylaws, some things to understand about the particular significance that they hold. They are very much sort of the law of the land for your particular HOA, as long as they don't contradict the actual law. The law considers the CC&Rs and the bylaws as fairly literally a contract between the HOA and each individual homeowner. So if the HOA is pursuing a homeowner for violating the governing documents, if there's a lawsuit saying a homeowner has violated the governing documents, really what we're talking about is basically a breach of contract lawsuit. Same thing if a homeowner says the HOA is failing to enforce the governing documents, failing to maintain the property the way they're supposed to. There again, we're talking about basically a breach of contract argument there, a breach of contract claim. If I'm a homeowner and I don't like something that's in the CC&Rs, and I sue the HOA, and I say, Your Honor, there's this provision in the CC&Rs I don't like, I think you should throw it out. It says I have to deal with the landscaping on my property. I don't think I should have to do that. I think the HOA should have to do that. I want you to throw that out. The court will typically say, sorry, Mr. Stewart, you're out of luck. The CC&Rs and the bylaws have a particular authority. They're a contract with the homeowners. They have to be voted on by the homeowners before they can be changed. Everybody is assumed to have, even though a lot of folks don't, you're assumed to have read them cover to cover when you bought the property. There's actually a court decision that says you are deemed, as a matter of law, to have agreed to every word that's in your CC&Rs. So if you bring a lawsuit challenging that document, a court will typically say, I'm going to err on the side of deferring to whatever is in those documents. I'm not going to change anything as the court. I'm going to defer to what's in there unless it's a completely unreasonable and ridiculous provision. I'm going to leave it alone. And every homeowner in that HOA is stuck with those words until there's a membership vote to change them. Rules are something different. Rules are a different animal, and we use all kinds of different words to talk about rules, operating rules, policies, regulations, but they are a different animal from the CC&Rs and the bylaws. The board, you guys, at any time can put a set of rules into place, and you don't need a membership vote to do it. You have to tell the members what's going on and give them an opportunity to voice their opinion and make comments on your proposed rule. But the board can put a rule into place anytime it wants, as long as you go through that process. And we'll talk about that process more later on. But the point for right now is a court will not grant the same deference to a set of HOA operating rules that it will to the CC&Rs and the bylaws. If I'm a homeowner and I don't like something that's in a set of HOA rules, and I bring my lawsuit, a court's going to be much quicker to say, you know what, board, I think you went too far with this one. I think you exceeded your authority with this one. I'm going to strike that part of this rule, or I'm going to strike the entire rule. I'm emphasizing this because when we're talking about amending your governing documents, we're talking about these two right here, the CC&Rs and the bylaws. That's most of what we're talking about today that have a particular authority and power within the HOA. We're not really going to be talking so much about rules. There's lots of things that go on with CC&Rs and bylaws that don't really apply so much to the rules. Okay. And I'm sort of putting the horse before the cart here a little bit here, the cart before the horse, whatever the metaphor is. You guys know what I mean. We'll talk about the process for actually amending the CC&Rs and the bylaws before we talk about why you want to do that, so you know what you're looking at for the process. Anytime you want to amend, or usually when you want to amend the CC&Rs or the bylaws, you need a membership vote to do it. The board cannot do that on its own. There are some limited exceptions to that. When there's a change in the law or some other situations, the board can do it on its own. But usually, if you're going to be making any substantive change to the CC&Rs or the bylaws, the homeowners are the ones that make that decision. You, the board, do not make the decision. You put it to the homeowners so that they can make the decision. Under Civil Code Section 4270A, usually the CC&Rs can be amended when the amendment has been approved by the right percentage of homeowners. Some CC&Rs will say you also need to notify the first mortgage holders or eligible mortgage holders. You need to pay attention to that. But generally, we're talking about usually approval by the current homeowners for a change in the CC&Rs. When they've approved it, and that approval has been certified in writing by an appropriate officer of the board, and that amendment is recorded with the county, then that document has now officially been changed, and the old CC&Rs don't apply anymore. That's now what governs your HOA. We'll talk more later on about supermajority requirements. When you want to know how to amend your CC&Rs or your bylaws for that matter, The document itself tells you how many homeowners have to approve the change. Is it a majority? Is it 60%? Is it 66%? Is it 75%? How many homeowners have to approve this change in the CC&Rs of the bylaws? It's in the document itself. If it's not in the document itself, there's a part of the code that says, then we're going to approve it by a simple majority of the members. But when we talk about the whole idea of amending your CC&Rs, this is basically the process that we're talking about. Same thing for the bylaws. You have to have it approved by the requisite percentage of homeowners based on what the bylaws themselves say. That amendment then gets signed by the appropriate board member or HOA representative. You do not record the bylaws with the county. The CC&Rs, for them to be official and in place, they have to be recorded with your county. They have to be part of the official records of the county. That's not true with the bylaws. They just have to be approved by the homeowners and then signed off on. We've been talking about the idea of a membership vote. The vote to amend the CC&Rs and the bylaws looks basically very similar to the vote to elect a board. We use the secret written ballot system with a double envelope, where what you're doing is you're sending out to the homeowners a packet that has the ballot, the proposed amendment to the CC&Rs, the proposed amendment to the bylaws, has all that together in a packet so they can read the whole thing. When our office is doing it, we include a cover letter explaining it in a couple pages what all is being changed. You send that out to the homeowners with a double envelope in the packet. They fill out the ballot. Yes or no, do you approve this change in our governing documents? They fill it out. They don't put their name or any identifying information on the ballot itself. They put the ballot in the inner envelope. They don't put any identifying information on the inner envelope. They put the inner envelope in the outer envelope, and there they put their name, their signature, and their on-site property address, and send that off to the Inspector of Elections. So just like with electing a board, that's the process we're talking about for having the homeowners sign off on a proposed amendment to the governing documents. Another sort of basic idea to be aware of as we're talking about this. The main thing I'm going to be talking about tonight is the idea of a restatement of the CC&Rs and the bylaws. That is a complete overhaul of the CC&Rs and the bylaws. We're going to rewrite and reorganize the entire thing. And we'll talk about why that's important, restatement. The other approach to amending the CC&Rs or the bylaws is to do what we call a spot amendment or a limited amendment. And the idea there is we've got one particular provision that's making everybody crazy. It says the homeowners are responsible for the flooring. We want the HOA to be responsible for the flooring. It says the HOA is responsible for the plumbing inside a homeowner's unit. We want to make that the homeowner's responsibility. There's one provision that right now we want to change. We're just going to hold a vote on changing that provision. When you do that, what you end up with is we've got our original CC&Rs, plus we have an amendment that has that one change to it. And so people have to keep track of two documents now. The benefit to doing it that way is that short term, it's cheaper. There's one particular issue that's in everybody's craw right now. You've taken care of that issue. You haven't bitten off the whole production of completely restating the CC&Rs and the bylaws. The downside is that long term, it's probably going to cost you more and cause more confusion. The most effective sort of financial way of dealing with these things is to do a full restatement of the entire thing. That way you're addressing all the issues that the members are upset about, all the issues you as board members are upset about, all the changes in the law. You restate the CC&Rs, you restate the bylaws to do everything at once. It costs a lot at that moment in time, but what you're doing is you're saving yourselves the headache of dealing with a lot of little issues along the way, a lot of spot amendments along the way that get confusing for folks. That was you? Okay. So, like I say, we'll be mainly talking about the idea of completely overhauling the CC&Rs and bylaws, but another approach, if you have a limited issue, is to do just that spot amendment that addresses the one issue or a couple issues at once. When you're doing the membership vote to amend the governing documents, same basic timeline as a board election. The packet that I described a moment ago is going to go out to homeowners 30 days before the vote is being held. 30 days after, and they can send it into the Inspector of Elections anywhere in that 30 days. They can send their ballot in. After 30 days is up, the Inspector of Elections counts all the votes at a meeting, tells everybody what the outcome is. Did the amendment pass? Did it not pass? And then 15 days after that meeting, the outcome is posted for homeowners to see so they know what happened with that vote. We'll talk more about that process as we go along. I touched on this earlier, but again, to differentiate the CC&Rs and bylaws on one hand from rules or policies or regulations on the other hand, this is the process for that. There is no membership vote to change a rule or to adopt a new rule. What you have to do is make sure that the rule is in writing. It falls within the board's authority under the law, the Articles of Incorporation, the CC&Rs, and/or the bylaws, meaning the board has some authority to pass this rule. They can't just make up, you guys can't just make up a rule that's out there in left field and has nothing to do with anything. It has to somehow derive its authority from the law and your governing documents. And it can't conflict with any of those authorities. But as long as it does those things, it's adopted in good faith, it substantially complies with the law, and it's reasonable, you've got your rule. You can adopt that rule. And you do that process by sending it out to homeowners at least 28 days ahead of time. Dear homeowners, we're considering adopting this rule. Here's what it looks like. Here's why we're looking at this. This is about electric vehicle charging stations. This is about installing solar on your home. This is about rental restrictions. This is about accessory dwelling units. We're trying to clarify how our community is going to handle these issues. So here's a rule. Please look it over. Let us know if you have any comments. Send them to our manager. Send them to AMC. And then when the board actually holds the meeting to consider adopting the rule, your obligation at that point is to take into consideration the comments you got and get, good faith consideration of those comments. You guys actually make the decision, are we going to adopt this rule or not? Are we going to change it? We've got 20 homeowners that are up in arms. They don't like the rule. They think it's a really bad idea. They're all concerned about this one particular line. Maybe we're going to change that line. Or we've got 20 homeowners who think it's a great idea. They're all in support of it. Nobody's against it, or nobody said anything. But your obligation is to at least give some consideration to what the homeowners have had to say, because they don't get a vote. So you guys are going to make the decision, but you're going to consider what they had to say. You're going to do it at an open meeting. And if you do, in fact, adopt the rule, you send notice to homeowners within 15 days of adoption. And that's the whole process for adopting a rule. No membership vote, no ballot, nothing along those lines. And that's why it's critical, because of that court challenge I talked about earlier, that when you're putting together a rule, you work with our office, you work with counsel to make sure whatever's being said in that rule comes from your authority under the law and under your governing documents, that you're not saying something your governing documents don't authorize you to say, because that's what brings on the legal challenge. Again, that's rules or regulations or policies, and not most of what we're talking about today. I talk about it to distinguish it from the processes we're going to be talking about. Okay, so why do you want to update your CC&Rs? I was looking at, where did I have that? In getting ready for this presentation, I was looking over the governing documents for some of the HOAs that are having the most trouble right now, having the most legal issues, that they need assistance right now, and try to get a sense of where they stood with their governing documents. I had one where their original CC&Rs were adopted in 1971. They did a full-blown rewrite or restatement of those CC&Rs about 20 years later in 1992. They did another rewrite about a decade later in 2001. In 2016, they did some spot amendments. We did, we're going to change this provision here, this provision here. 2017, they rewrote everything again to pull those spot amendments in. And they're actually now working on another one about a decade later. That gives you a sense of what some HOAs might see over time. You have 1971, 1992, 2001, 2017, and now 2025. And there's some bigger gaps in there than I would recommend. Typically, we say 5 years from when you last changed your governing documents is when you want to start thinking about changing them again. The process of changing them could itself take a few years. But typically, 5 to 10 years is about how much time you want to wait before changing things, because the laws change so much over time. And we'll talk more about the issues that come up. But that's a big concern, is the laws changing over time and making sure you're up to date with those laws and you're up to date with the issues that are affecting your community. The Davis-Sterling Common Interest Development Act, which again is the main body of law governing HOAs in California, that was first passed in 1985. I have HOAs today that have governing documents from 1971. In the 1970s, I've seen the 1960s, from 1980s, governing documents that were put into place before that law was even in effect, which means you might have all kinds of things that are said in your governing documents that no longer make sense under the current state of the law as of 1985, where they're not using the same terminology that the law uses. They're talking about things in a different way. They're sort of making assumptions that don't apply anymore. They could be hugely out of step with California law. The Davis-Sterling Act was reorganized in 2014, basically overhauling all the statute numbers so that references to that law from 2013 or earlier are now out of date. If you have governing documents that were put in place between 85 and 2014, they're probably using the right language or the same basic ideas, but they're probably also referencing laws that no longer exist because the numbering was changed. And you give them to council, you give them to our office, and we can figure out what it is they're supposed to be saying, but it ends up asking too much of both the homeowners and the board members to have to go online. Okay, it's talking about Civil Code Section 1365. That doesn't exist anymore. What law is that now? Where is that? And what does that mean when I take that together, that change in the law with what our CC&Rs say? What does that mean in terms of what the HOA is supposed to be doing, what it can do, what it can't do? That's too much to ask of anybody. And you end up having to call in counsel for these issues. So if the CC&Rs aren't up to date with the current state of the law, it can be a challenge for both the board members to know what you're supposed to be doing and the homeowners to know what it is they're supposed to be doing. Those are sort of the major changes in the law, but just in the past 5 years, we've had significant changes to the law regarding HOA elections, regarding rental restrictions, regarding meeting requirements, accessory dwelling units, and just recently regarding fines. There were, with SB 323 in 2020 regarding elections, there was a brand new law. Yes, sir.
Yes, going back to the previous slide,
Mm-hmm.
if you have a community manager that is pretty savvy in what's going on and
Mhm.
keeps up to date, why can't you continue to use the same CC&Rs and have that verbally updated by what you can and cannot do during your discussion?
That's a great question. Thank you for asking that question. The short answer is because it puts the manager in the position of being a lawyer, and that's not good for anybody. It asks something of the manager that they haven't been trained to do. They have their area of expertise. Lawyers have a different area of expertise, but you should never be saying to your manager, okay, dear manager, figure out what the law says now and tell us what we're supposed to be doing on it. Tell us what our legal obligations are because of that change in the law. The bigger issue, though, is that it puts everybody, including you guys and the homeowners, in the position of guessing about what it is you're supposed to be doing. Most of the time, the changes in the law aren't clear in terms of how they affect your particular CC&Rs. Most of the time, it requires taking what the law says, sitting down with what your CC&Rs say, and figure out, okay, we need to change this word. We need to take out this whole paragraph and put in a new paragraph. We need to take out this entire page and put in a completely different page. There's an analysis that goes on with that it's not fair to ask homeowners to know the CC&Rs say I'm supposed to do this. I didn't know the law says I'm not supposed to do that anymore. The HOA is supposed to do it. Or I'm now supposed to do something that I wasn't supposed to do. How are the homeowners going to know that? So it's sort of, it asks too much of your manager, it's a different area of expertise, and it puts too much pressure on both the board members and homeowners to guess about what it is they're supposed to be doing. So I hope that helps. That's a great question, an important point. Going back to this here, California law changed significantly in 2020 regarding election rules, where basically the legislature said everybody had to now change their election rules. It was already a requirement that everyone have election rules, but the law said in January 1st, 2020, every HOA in the state has to change their election rules to say new things. There was a law passed a year or so later, AB 3182, that basically said everyone has to change their CC&Rs and bylaw, or the CC&Rs regarding rental restrictions, because we've just changed the law regarding rental restrictions. And that's one where I think eventually they got around to saying, because this is due to a change in the law, you don't necessarily need a membership vote, but you need to make that change in your CC&Rs. We've had a lot of changes in recent years regarding whether or not you can do meetings entirely virtually. We had the pandemic where everyone sort of started doing, or a lot of folks started doing meetings entirely virtually, even though the law didn't envision that. There were several changes in the law in recent years where now you can hold meetings that are entirely virtual if that's what your HOA wants to do. But those are huge changes. Again, just in the last 5 years. Lots of complicated changes every year regarding accessory dwelling units, where I can't even keep track myself of all the changes half the time. And of course, just a few months ago, changes regarding enforcement procedure and the fines you can impose, where if you haven't changed your fine policy and your enforcement policy since July of this year, it's out of date. It no longer says what it's supposed to say. These are sort of some very specific examples of changes in the law that put the onus on the board to figure out and work with council to figure out what changes we need in our governing documents. There are also big issues going on with HOAs in general, with insurance, with maintenance, with reserve obligations. I'm talking about the condo tower collapse in Surfside, Florida a few years ago, where in a few seconds an entire or portion of a tower collapsed and 90-odd homes were destroyed and lots of people died. That sent shockwaves through HOAs across the country. Fannie Mae started changing their requirements for guaranteeing loans, where now they wanted all kinds of detailed information about whether it was likely or not that a particular building was going to fall down. Lots of sort of substantive, subjective, nuanced information Fannie Mae is now requiring anytime they're asked to guarantee a loan for a homeowner within a development. That puts a lot of pressure on the HOA to be on top of those issues. We've got aging infrastructure where HOAs across the country are getting older. We've got wildfires in California where insurance carriers really would rather be anywhere else right now. And I'm not sure if it's happened to anybody in this room, but we see it with our clients all the time. Last year, the premium for insurance was $50,000. We just got non-renewed for no particular reason. Now we're gonna have to go out to the secondary market, and next year our premium is gonna be $500,000. Huge changes in things that are affecting HOAs and putting a lot of pressure on HOAs. And part of what we'll talk about more as we go along is ways that you can amend your governing documents where it's not gonna fix these things, but it can ease the strain a little bit. Questions like, okay, what part of that insurance is going to be held by the homeowner versus the HOA? How many of these different types of policies are going to be mandatory versus elective, where the board has some discretion whether to take on those policies? Things along those lines. This just gives you an overview of some of the issues that can come up. Other changes in the law of the last decade or so regarding signage, antennas and satellite dishes, of course solar power, electric vehicle charging stations, the internal dispute resolution process, water conservation, landscaping, sort of drought-resistant landscaping issues. Those have gone through big changes in the last 10 years, where if your CC&Rs are more than 10 years old, they're probably out of step with a lot of these issues. And something else we'll touch on more later is if your CC&Rs were put in place by the builder, they probably have all kinds of things in them that don't really do you any good anymore and maybe actually be contrary to the HOA's interest. If you've got the word declarant all over your CC&Rs, well, that's the builder. That's the person that put the declaration, the CC&Rs in place. That's the declarant, that's the builder. And they like to carve out all kinds of rights for themselves and privileges for themselves where X and Y and Z can't be done unless the declarant signs off on it, and things that don't necessarily make any sense once the builder isn't around anymher. There's always a certain period of time where you've got builder reps still on the board, but once they're gone, it doesn't make sense to have those provisions in there anymore. So that's another issue that comes up with needing to update your CC&Rs. And more generally, over the life of an HOA, you realize, particularly as a board member, particularly if you're on the board for a long time, you start to realize there are things that just don't work for your community. They're in the governing documents because the builder put them there because they put them in all their governing documents, but it just doesn't work for us. We've got situations where the homeowners are responsible for maintaining things. It doesn't really make sense to have the homeowners maintain. The homeowners are responsible for, we've got attached units. The homeowner's responsible for the roof over their particular part of the unit, but really it's one big roof for 4 different units. Why are we going to have those 4 homeowners try to coordinate the work on one roof? That doesn't make any sense. Let's make that the HOA's responsibility. We'll increase assessments to pay for it, but it'll make it easier for everybody to deal with it. Or we have situations where the HOA is routinely having to go inside folks' residences to maintain things that it doesn't make sense for the HOA to be maintaining. So let's put that on the individual homeowner. Allocation of maintenance responsibilities, payment of insurance deductibles. If the HOA's policy covers a situation that really benefits one homeowner, is the HOA going to pay that deductible or is that homeowner going to pay the deductible? What makes more sense for your community? Lease restrictions, again, there have been some changes in the law there, but there's also things that the law didn't really address. Pet restrictions, it might be that when you first got the community off the ground, nobody really cared about pets running around off of a leash, and now they do, or the reverse is true. Vehicle and parking restrictions, all kinds of things where part of your responsibility as a board is to be paying attention to the things that are in your governing documents that don't really make sense anymore and need to be changed. What are the fights we're having to have over and over and over again with homeowners just because that's what the CC&Rs say? And can we change that? Can we work with council to change that in a way where we get rid of that problem for ourselves? Okay, and this is a little bit more detail here, but kind of recapping things we've been talking about. An HOA's governing documents can either serve as a strong foundation for your community or a source of confusion and costly disputes. A lot of the work that we end up with is the board coming to us and saying, Lance, our governing documents don't make any sense. We don't know how to handle this situation. This part over here says the flooring in the unit is the homeowner's responsibility. This part over here seems to say it's the HOA's responsibility. Now we have a flooring dispute. We don't know what we're supposed to do with it. Can you please give us some guidance? The more you have sort of confusing, contradictory passages in your CC&Rs, the more you're having to call folks like me up for issues that if you just fixed them, fixed the CC&Rs, you wouldn't have that legal issue anymore. It's essential that HOAs update their documents to comply with current laws, as we've talked about, and incorporate modern best practices to effectively govern their communities. And some of the important reasons that come up, conforming to current state law. We've talked about that a fair amount. But to be an effective management tool, the governing documents must accurately reflect current state law so that the board and management can be properly informed of their duties and obligations. California law on homeowners associations changes with each session of the legislature. Some years are rougher than others. I think last year, the last couple of years, there weren't a lot of big changes, and this year we get the fine schedule changes. Governing documents that have not been amended for a number of years may seriously mislead the board and manager as to their legal obligations. And that goes back to the gentleman's question in the corner earlier. Changes can save the HOA money. We've touched on this a few times, but maintenance and repair costs and insurance premiums are skyrocketing, especially in California. For most HOAs, especially those that are unable to secure an affordable insurance policy with the coverage required under the current CC&Rs, it may make sense to amend the CC&Rs to shift some of the maintenance responsibilities, the repair responsibilities, the insurance obligations from the HOA to the homeowners. We can take that on in a more cost-effective manner. And it's a judgment call for you guys. You know your communities. You know the people in your communities. You know the issues that you're dealing with. There are going to be times when it makes sense to take something that is a an HOA responsibility and put it on the homeowner. There are going to be times when it makes sense to do the reverse. This is something that's on the homeowners right now. It's causing a big problem for everybody. It's more efficient and effective and cost-saving for everybody if that goes back to the HOA. It's a judgment call. Is that for me? Correct ambiguous or inconsistent language. We've touched on this. Where it's unclear from the language what is expected of the HOA or its members, the governing documents are failing to carry out their intended purpose. Allocation of maintenance responsibilities, payment of insurance deductibles, all the things we've been talking about may need to be revised or adjusted to reflect the past experiences of the HOA. And this is where you bring your expertise in your personal community, your home and the neighbors around you. You bring that to bear as a board member and say, guys, we've got a problem with what our governing documents say. Let's get counsel to come up with something new for us to fix these issues. Ambiguities and inconsistencies make enforcement difficult and have the potential to result in extended disputes between the HOA and its members. I've got a few situations that I can think of right now where really the reason the dispute is happening and is causing a big problem between the HOA and its homeowners because there's something in the CC&Rs that's confusing, it's vague, it was written 20, 30 years ago, it wasn't quite as precise as the community now needs, and it's causing a dispute where the HOA is saying it means this, the homeowner is saying no, it means the opposite of that. You need to reflect modern developments in technology. You know, we see it all the time. There's some new technology that's coming out, and I want to say something to do with heat pumps that I think is going to be the next thing to make provide challenges for HOAs. But we've got, you know, video conference meetings, home offices are more common, satellite dishes, solar, electric vehicle charging stations. If your governing documents don't even reference these issues, it's going to make it very hard for you guys to address them when they come up. You get an architectural application for solar installation, or somebody wants to install their own electric vehicle charging stations. You don't have anything in the CC&Rs referencing that. It makes it hard for you guys to draft even a rule that can address those things. Because as your counsel, I've got a hard time pointing back to something in the CC&Rs that says you get to make that rule, like we talked about earlier. Get rid of obsolete language. You know, again, if it's from the developer, it usually contains provisions that only help the developer, allowing a sales office on site, requiring a special dispute resolution procedure for complaints against the developer. We talked earlier about construction defect. If your community is more than 10 years old, but you still got provisions in there talking about how you need to pursue a construction defect claim against the builder. First of all, the law has made that antiquated anyway, but you need to get rid of that. It's not doing you any good anymore if you're more than 10 years old. And this kind of goes back to the gentleman's question in the corner. The law is being changed every year. There have been a significant number of changes in recent years that would warrant an update of your governing documents. It's easy to sort of say, well, gee, as it changes every year, why bother? And the answer to that is that it's an accumulating, sort of exponentially gathering problem the more changes that happen that you haven't gotten pace with. There are the big changes, there are the little changes. You want to make sure you're up to date with the big changes. And again, if you're 5 to 10 years from when you last updated your governing documents, you need to be taking a serious look at that. Okay. We've talked a lot about the CC&Rs and sort of the meat and potatoes issues for your community, the maintenance and the insurance and all these things. I said earlier that bylaws are more procedural in nature, but there are a lot of things you can change in your bylaws that can also make your lives a little easier. So, for example, we touched on earlier, there's a handful of situations where the law says if you're going to hold a membership vote, you have to use the secret written ballot with a double envelope system. Board elections, passing a special assessment, amending the governing documents. The law says that's the process you have to use for that type of vote. There are other votes that come up that the law doesn't address, though. And one thing you might want to consider is, okay, if we have a vote that comes up that the law doesn't say what process we're supposed to be using, that can cause a lot of confusion. Where, what are we going to do? Are we going to use the envelopes and the double envelopes in the secret written ballot? Are we going to use a show of hands at a meeting? What do we want to do? For purposes of consistency and making sure everybody knows what process to expect with any vote, and you're not getting sort of needless challenges to a vote just because it used a different system, one thing to consider is, do we want to use that mail-in ballot procedure for all of our votes? Put that in your bylaws, so you have a consistent procedure anytime there's a membership vote on anything. We got a few things that are sort of antiquated and don't make any sense anymore. The idea of cumulative voting, we don't really need that anymore. The idea there is, you've got a certain number of open seats on the board. You can rearrange your votes however you want to. You get 5 votes for 5 candidates. I'm going to give 3 to this guy and 2 to this person and not vote for anybody else. There's not really a whole lot of logic or purpose to that anymore. That's something you might want to consider getting rid of, because it can create needless confusion when you're dealing with the ballots that are being issued and how you're actually tabulating the votes. And it makes it more likely there's going to be people who mark up their ballot in a way that they can't actually do because they're confused by how that's supposed to work. Proxies is something that doesn't make much sense anymore. The idea of a proxy was supposed to be, we're going to hold a membership vote. Everybody needs to come out Thursday night and we'll do a show of hands and we'll see what the outcome of that vote is. Well, I can't be there, so I'm going to ask my neighbor to show up for me and cast my vote for me. I'm going to give him a slip of paper that says he can cast my vote for me. If we're doing votes that way, then the idea of a proxy makes sense. But that's not how we do votes anymore. We do votes with this mailed-in ballot, and you have 30 days to mail the ballot in. There's no real point in giving somebody else the right to write in your vote for you when you can mail it in whenever you want in that 30-day period. There's no reason to have the idea of a proxy at all. That's sort of an antiquated idea that doesn't make sense. You might want to take that out of your bylaws. Election by acclamation. The law has flip-flopped back and forth a couple different times in the last few years on election by acclamation. Now you can do it, but there's a specific procedure you have to do. But it would be helpful to have that in the bylaws so that homeowners know what to expect. If you have a board election where you've got 5 seats open and 5 candidates, or you only have 3 candidates for 5 seats, you put in writing in the bylaws what process people should expect so that they know when that board takes their seats, it's not somehow an illegitimate board. They know they went by the process they're supposed to go by. Annual meetings is another one where there's not much use to that anymore. Yes, sir.
When you have ballots set out,
Mhm.
votes, we don't get the percentages back to make it a legal vote.
Mm-hmm.
So we had to hold off for 30 days to go ahead and see if it would challenge our decision.
Mm-hmm.
Because, pathetically, ballots came in.
Yeah.
37 out of 104.
You didn't make quorum?
Huh?
You didn't make quorum for that vote?
Yeah.
We're going to get to that in just a second. Great question. Thank you very much. In fact, that's the next bullet. I'm going to get to that in just a moment. Annual meetings, again, sort of an antiquated idea. Used to make more sense to have, we're going to do our board election. We're going to do sort of the big business for the year once a year at a meeting that everybody's going to come out to. At a point where we're doing all of our board elections via a mail-in ballot, it doesn't really make sense to hold an annual meeting anymore. And there can be a lot of confusion in the bylaws sometimes between when you do your board election and when you do annual meeting. A lot of times we have governing documents that seem to say the annual meeting and the board election can be 2 different things, but people assume it's the same thing. It's a needless thing. You can get rid of that. And to your point, sir, a moment ago, get rid of the quorum requirement for board elections. There's no need for it. When we're voting for president or senator or governor or whatever, we don't say, well, we're only going to count the ballots when we have a certain number of people voting. But that's what a quorum is. We're not going to start counting ballots until we get 25% of the homeowners voting, or 30%, or 50% of the homeowners voting. And I see it with my clients all the time where they're stuck in limbo. They can't get the election done. They've been trying to do it for 4 or 5 months. They've reconvened 4 or 5 times, even with the change in the law to say you can reduce it to 20%. A lot of times folks still can't get it done. And they're just stuck in limbo. And I've got communities where for years they haven't been able to complete an election because they can't meet that quorum requirement. Sometimes there's a way of interpreting the bylaws so that maybe it turns out the quorum requirement doesn't actually apply. But if it's there, you're stuck with it, you need to get rid of it. Now, the downside to this is you still have to complete a membership vote on amending the bylaws to make that change. And if your problem is voter apathy, where people aren't casting ballots, it's sort of a vicious cycle. But ideally, what you're going to do is amend your bylaws to get rid of that quorum requirement because there's no need for it. Whoever gets the most votes wins. That's all a board election should be. Great question. Thank you. Okay, so this is a little bit of a recap here. One thing to consider is why would you amend your CCNRs? One thing to consider is revising definitions. A lot of times, obsolete, outdated words don't make sense anymore. You need to change those or modify them so they're more intelligible to the folks reading them. Part of what we try to do when we're rewriting the CCNRs and the bylaws is put it in a way where folks can understand what's being said. You get CCNRs from 1962, a lot of times they're using language that doesn't make sense to folks anymore. Use restrictions, are you going to allow for home offices? Are you going to clarify the pet restrictions, the parking and towing restrictions? Are you going to let short-term rentals like Airbnb type of things? Are you going to limit leases? Maintenance issues, we've talked about that. Assessment collection, updating your collection procedures could mean that the HOA is able to bring in a lot of money that otherwise was going to have to be written off as bad debt. We talked about the insurance provisions and the approval requirements. Again, this is it can be sort of a vicious cycle, but if you've got approval requirements in your CCNRs, we need 75% of the homeowners to approve a change in the CCNRs. What you want to do is get rid of that. If you're restating the CCNRs, get rid of that provision. Again, you got the vicious cycle where we need folks to vote for that in order to get rid of it. We'll talk more about a possible solution to that later on. But if you, again, this is a good reason for doing the restatement, doing everything at once rather than limited provisions. So you're including all that. You give folks a lot of reasons to want to show up and participate in the vote. But if you get rid of that, you're not going to get rid of the approval requirement, but you can reduce it from 75 to a majority or something that's more reasonable for your community. Okay, we've touched on the idea of election rules. Typically, we recommend that if you're going through the process of restating your CCNRs, restating your bylaws, you need to be updating your election rules at that point as well, because since the bylaws are procedural in nature, there's going to be things that you say in your bylaws that affect your elections, and things in your election rules that affect your elections as well. They go hand in hand. So you want to make sure that when you're restating your bylaws, you've got a new set of election rules that goes hand in hand with what you're saying in your bylaws. Again, HOAs have been required to have election rules since, I believe, 2006. The change in the law I talked about in 2020 says that if you haven't updated them recently, you have to do it 90 days before an election. You can't do it any closer to the election than that. But I touched on earlier, January 1st, 2020, SB 323, there were major changes to what those rules have to state, and there was the requirement that everyone has to change their election rules to reflect this. There were changes to director qualifications, the homeowner right to vote. You can't deprive people of their right to vote in HOA membership votes anymore. The election timeline, the notices that have to go out, there were huge changes to that. Generally speaking, Civil Code Section 5105 requires the HOA to have strict compliance election rules that address things like what opportunities candidates have to express their point of view and advocate for themselves getting elected, what the candidate qualifications are, how you're selecting an inspector of elections, how you're handling the election records, making sure everyone has access to a ballot, the timing and the content of the ballot packet to homeowners, whether you're getting into electronic voting or not, and some other issues. You need to make sure you have election rules in place that address these things, and you need to make sure that they say essentially the same thing as your bylaws say. That's why we're talking about this in the context of amending your bylaws. Even if HOAs have election rules, if their bylaws are updated, the election rules need to be updated to conform to those. If you're doing a full update, we recommend revising those election rules. So I just said the same thing 3 or 4 times in case you guys weren't paying attention. I hope it came through. Getting the vote, and this goes back to your point earlier. Voter apathy it's a real problem, and we see it all the time, where the board is doing all they can to try to fix things for the HOA, either by amending the governing documents or holding a proper election or passing a special assessment, and folks just aren't participating. And there are some things you can do to try to encourage participation. Now, getting rid of the quorum requirement is a big one. But again, passing those amendments still requires the homeowners to show up in the first place. You can do things like going door to door to remind folks to vote, or even passing them a ballot here. If you haven't voted yet, here's a ballot. Do not gather ballots, okay? And that's something that folks get tripped up on from time to time. The way the law is right now, the ballots can only go from the homeowner to the inspector of elections. So don't put yourself in the position of, I'm going to gather your ballot, I'm going to stand here while you're filling it out, and I'm going to put it in the mail to the inspector of elections. But what you can do is remind folks the importance of voting and make sure they know how to get a ballot if they don't have one. You can also offer incentives for them to return their ballot. You know, your ballot is a ticket to a pizza party. We're going to have a pizza party for everybody on election day, and bring your ballot and you get a slice of pizza. It gets you a raffle ticket for a gift card. You're not telling folks how to vote. You're just giving them a reason to vote. The other piece of this, though, is that the board can't advocate for the outcome of any particular membership vote. It used to be the case that, if a board was trying to pass a special assessment or amend the governing documents, the board might say things like, please vote yes, right? Or please cast your vote in favor of these things. Don't do that. Stay away from that. Your role as a board member is to educate the homeowners. There's a reason we're putting this in front of you. There's a reason we want you guys to at least consider a special assessment. There's a reason we want you guys to consider amending your governing documents, but you're not going to tell them how to vote. There's case law situation where you would have thought what they said was okay, and the court said, no, the board went too far in sort of advocating, please vote a particular way. What you want to do is make sure homeowners understand the issues, they understand why they're being asked to consider this, but you're not telling them how to vote. But I say that to say anything you do to encourage them to participate, to encourage them to vote, that's fine, as long as you're not going that one step too far. We touched on this earlier, the problem of the supermajority approval requirement. The bylaws of the CC&Rs say they can't be amended unless 65% approve it or 75% approve it. Some really ridiculous thresholds where the HOA is never going to get it done. There is a law, Civil Code Section 4275, that gives a procedure for addressing that, where we held the vote. A majority of homeowners want this change. A majority of homeowners want to amend the CC&Rs, they want to amend the bylaws, but we couldn't get all the way up to 75%, Your Honor, so can you please help us out? You petition the court, you do this with counsel, but you petition the court for approval and adoption of amendment saying a majority of homeowners approved, but we couldn't reach that supermajority requirement. You have to show what efforts you went through to try to encourage the vote. Like you were talking about earlier, folks aren't showing up. I've had it where we do 5 or 6 rounds of offering raffle tickets and pizza parties and everything else to try to get the vote to turn out, so we can at least get that majority in favor. Get to enough votes where we can open the ballots and figure out what the outcome is. But you show the court what steps you went through to try to encourage people to vote. You tell the court what the actual outcome was and what outcome the governing documents required. And usually these are pretty easy to get courts to sign off on. I have had some where a homeowner was up in arms and challenged it. And usually the court still wants to see this happen anyway, because we don't want folks, this is meant to be a safety valve. We don't want HOAs stuck in limbo where they can't get an appropriate amendment done, even though a majority of homeowners want it, just because there's a ridiculous requirement in the governing documents themselves. So there is a tool for getting that done if you're dealing with that supermajority threshold. Okay, and again, not to shill for our firm necessarily, but to give you guys a sense of how we handle doing the full-blown restatement of the CC&Rs and bylaws. The first thing we do is give you a questionnaire. And that's our way of finding out from you, what are your pet issues? What are the things that you're really concerned about as board members? What are the things that you're hearing from homeowners you're really concerned about? What are your primary goals in restating your CC&Rs and your bylaws? Is it a maintenance issue? Is it insurance issues? Is it parking issues? Is it pet issues? What are the things that you're really focused on? What's front and center for you to have these governing documents amended and addressed? We review your existing governing documents to figure out what are the unique parts of your governing documents. What are the things that are specific to your community? You've got particular amenities that need to be addressed. You've got an on-site golf course. You've got parking issues. You've got weird formations. What are the things that are unique to your governing documents that we need to make sure we include in our proposed draft? We then put together a draft of customized bylaws and CC&Rs that are meant to capture all those things, capture what's unique about your community, capture what you've told us were your priorities, and also are up to date with the current state of the law. And you guys review that. We give you sort of notations or roadmap with that draft where we're saying in the side, okay, we made this change because of this change in the law. We made this change because you told us that pet restrictions were a concern for you. We made this change for this reason, and on down the line. You guys look it over and you vet it. And you say, okay, Angus and Terry, we appreciate all this. Here's the part that we'd like to see this part changed over here. We'd like to see this part changed over here. Once we get into that, we're sort of outside the flat fee that we offer, but we at least provide that first draft as part of the flat fee. That also includes a 2-hour meeting with the board where we're sitting down and going through everything and making sure you're satisfied with it. And then we draft and I mentioned this earlier, the cover letter to the homeowners. Folks are going to get, when they vote on this, a packet that's in excess of 100 pages long. We have to assume that most of them aren't going to read it cover to cover. So we put together a cover letter that's 3 or 4 pages long that boils it all down And sort of the same thing as the notations on the side, we're saying to homeowners, we changed this because of this change in the law. We changed this because we understand parking is a concern in your community. We changed this for this reason, but gives them sort of a 3 to 4 page cheat sheet for why these things are being changed. We always want to encourage homeowners to read the thing cover to cover. We don't want anyone reading it not knowing what they're voting on, but we try to make it as accessible as possible. So we put together that cover letter, we put together the ballot materials. If it passes, we update the election rules, provide you the documents for that once the bylaws are passed, and we coordinate recordation of the CC&Rs. I believe our current flat fee is somewhere around $9,000 for us to do this. We're happy to give you guys a proposal. It includes all these things. As I said, once we get past that first draft and the board has different changes they want to make, we end up doing some of that work on an hourly basis. But everything up here is part of that flat fee. So it gives you sort of the major pieces you need to amend your governing documents. Yes, sir. Yes, ma'am.
What's your opinion about having non-board members work on revising the documents?
That's a good question. Technically, there's nothing wrong with it. What I would say is make sure you're talking about an advisory committee only, where the final decision of what's going to be put to the members to vote on is being made by the board. The thing I always worry about with those situations is, as board members, you've taken on that fiduciary duty for the well-being of the entire community. Committee members who aren't board members haven't taken on that duty. They don't have the same sort of responsibility that you guys have taken on. And so there can be more of a tendency to not think about the big picture, but think about, my pet issue, the thing I really want to see happen. But if you do it as an advisory committee where the committee sort of gathers the information, they work with council. You always want to be working with council. You don't want a committee doing it on their own. But they've put together the information. They sit down with the board. They give the report. Here, board, here's what we think you should be doing, but the board makes the decision. I think that's probably fine. The other thing I'll say about committees, too, is you always want a charter for any committee that specifies, okay, committee, here's what you're being asked to do. And here's the authority you have, and here's the authority you don't have. Here's your role. And you always want that charter to terminate at a reasonable point in time. Don't have it just carry on endlessly into the future, but this committee is going to last for 3 months. You can always renew it at the end of 3 months. It's going to last for 6 months. You can renew it, but don't have it just carry on endlessly into the future. But I think the priority is making sure the board is making the final call. So I hope that helps. Yes, ma'am.
So our CCRs have a lot of things that may not be tied to law,
Mhm.
like no weeds, no welcome signs.
Mhm.
Can that be addressed when rewriting?
Absolutely, and I did touch on earlier, there's been changes in the law about signs and what you can and can't do with signs. That's something, that's a reason to want to update the governing documents and make sure you're capturing the things that are important to your community, but not running afoul of the law. But yes, absolutely, that's exactly the type of thing we're talking about. I think, how are we doing on time? Okay, I think that's the whole presentation. Does anybody have any other questions? Yes, ma'am.
It has never been brought up yet in my community, but I do know like a lot of people are driving electric vehicles,
Mhm.
but I just want to like ask ahead of time. So like if a homeowner wanted to bring up to the board about maybe installing a charger in our community, like
Mhm.
I mean, like the changes that you're saying that we need to make, right? So
Mhm.
what's your best advice about?
It's like a couple other things like solar and accessory dwelling units. It's a very complicated and technical issue. The first question you're going to have is, and the first issue the board's going to need to be dealing with is what type of community are we? Are we a condo where most of the property is ours? Single family homes, okay. So it's going to be, it's conceivable that somebody could just install something on their property in a way that doesn't necessarily affect other homeowners. It's possible that it would affect them, though, and that's the type of sort of technical issue you get into. Something that I'll say to you guys on anything along these lines, whether it's the electrical vehicles or solar or things along those lines, is you want to talk to an expert in that field and get an understanding, okay, this homeowner wants to do this type of thing, or we think homeowners might want to do this type of thing. What's that going to mean for us? Does that, if I install something on my property, does that affect your property or does it not affect your property? I don't know. You guys, your responsibility as board members is not to be experts in everything, but to know when you need an expert. But the law gets very complicated on these situations with the electric vehicles, and of course the technology is changing every day. But you want to sit down with council to figure out how far do your governing documents go in anticipating this issue, sit down with an expert on what are the practical realities of doing it in our community, and ideally update your CCNRs to envision that reality and anticipate what's going to happen. It's great that you're thinking about it now before it's actually come up. And there's going to be a level of detail where you probably are going to end up adopting a policy that's specific to it, but you want something in your CCNRs that at least gives that foundation for the board to pass a rule along those lines. But yeah, it's like a lot of things where if it's not hit your community already, you do need to be thinking about it. It's great that you are thinking about it, if that helps. Yes, ma'am?
I was very intrigued by your comment about doing away with annual meetings.
Yep.
That is the only time the associations typically get a good turnout
Okay.
at board functions. So I kind of wonder why you think it's a good thing to get rid of it.
It's a great question. And like all these things, it really depends on your judgment about your community. If your community likes having an annual meeting, because I mean, how much do we see each other at all these days? And it's an opportunity for folks to get together and talk and have pizza and talk about the HOA's business, great, do it. My point was more, it's not a requirement. It's not something that you need in order to be able to conduct the HOA's business. If it's nice for the community, great, do it. If it's a good opportunity to make sure everyone knows what's going on and say, okay guys, we put together our budget for this year, here's what we're looking at, here are some issues that we think are coming down the pike, we're trying to do this asphalt project, we're trying to do this project, we think there might be a special assessment, whatever, it's a good opportunity to check in with folks. And I love that idea. My point was not, you shouldn't do it, it's that you don't have to do it.
So bifurcating the voting for board members from an annual meeting, because right now, all the associations that I'm involved with, unfortunately, I have 3 of them.
I'm sorry.
Require the election and the annual meeting.
It'd be the same thing, yeah.
So you're saying we could bifurcate that?
Yeah. You could change your bylaws to say, we don't require that annual meeting anymore. You could change your bylaws to say, they don't have to be the same thing. They don't have to be the same time as the board election. And that's something where, I was talking earlier about the quorum requirements, there are bylaws that are really confusing when it comes to, okay, we're supposed to hold the annual meeting on this date. We were supposed to do the board election this way. It's never really clear whether the board election is supposed to happen at the annual meeting or not. It doesn't really say one way or another. So what are we supposed to do? The practice might end up being we do them at the same time because that makes sense to us. But there's all kinds of things in bylaws where it's not really clearly spelled out, and one reason to amend them might be to clarify that and say, okay, we realize for our community it makes more sense, we want the annual meeting. We don't necessarily want it to be the same time as the board election. We want people to have, we get together January 5th every year and see everybody for a minute, but it's not the board election. But again, it's your judgment, what's best for your community and what are you going to recommend to the homeowners.
So back to the quorum question.
Mm-hmm.
If you receive mail-in ballots that meet the threshold required for a valid election,
Mm-hmm.
why would some manager come and say you have to have a quorum in person? That makes no sense to me.
You don't have to have a quorum in person. There's a part of the law that says quorum is determined by the number of ballots received, and a ballot received is counted the same as a person who's physically there. You don't need to have folks physically show up.
That's what I thought.
I thought I saw a hand over here somewhere. Yes, sir. Come back. Hold your thoughts, sir. Go ahead.
Say that last sentence again about the quorum, because I've always wondered, like, is a quorum a percentage of the total homeowners that are in that development, or is it a quorum of like whoever shows up at a meeting?
It's a great
At least
question.
in our bylaw, at least in our thing, it's very murky as to what a quorum actually is.
Yes, and that's something that needs to be clarified in your bylaws. And I see that language all the time where it's not really clear what are they talking about who needs to show up physically at the annual meeting? Are they talking about how many votes need to be cast? What I would say right now is because the law says every vote cast counts as a person showing up for that election, that's what defines quorum. So the quorum requirement in your bylaws is we need 25% of homeowners to show up to hold this election. What we're talking about is 25% of the homeowners, total voting power of the HOA, 25% of that power casting a ballot. And it might be too that your bylaws don't actually say you need the election to happen at that meeting. And that's where it gets confusing too. But that's definitely something that needs to be clarified in your bylaws, I would say.
And then my second question is, I'm curious what your take is on, like, a lot of our associations, there's a rise of rentals.
Mhm.
And curious I've heard, it's a lot, it's probably 30 or 40% now. And I'm nothing against it, but
Mhm.
it's I didn't, and I've heard some people say like there's caps or limitations, but I don't know how you could legally do that, or how is that even possible? Is that wrong, or is that right? Are there restrictions, and if so, who has the legal authority to restrict somebody what they can and can't do with their property?
Right.
Or, I'm just curious what your take is on that.
It's a great question, and it's
Because I get a lot of questions as a board member from other homeowners, like, why are there so many rentals? They can do that, and then also, having rentals is difficult on a board and in a management company too.
Yep.
To communicate with an owner out of state, out of country, management, a management team, a renter, it's a whole thing. So
Yep.
I'm curious.
There have been a few changes in the law about rental restrictions in recent years. The big one was, you're taxing my memory a little bit here, but the big one is that you can't have caps below a certain point. I believe it's 20%. That changed to that.
How
Where,
do you even cap it all? Like, how do you do that?
well, the thrust of the law is that you shouldn't do anything, the HOA shouldn't do anything that makes it hard for people to rent. Because the design of the law is people are having trouble finding places to live. We don't want HOAs making it harder for people to find places to live because they're preventing rentals. So the idea of the cap was to say, okay, you can have a cap, but it can't be lower than this. You can't have a 15% cap on rentals. You're absolutely right that it causes other problems, though, in terms of telling people what they can and can't do with their property. And it gets very complicated because now you're talking about a wait list. We've got, 20% of the homes are being rented. We've got 40 other people that want to rent their properties. What are they doing with that property while they're waiting for somebody to stop renting their property or sell it off or rent it to somebody else? They're waiting in line. What are they doing with their property in the meantime? It creates a lot of additional issues. I've got a situation right now where a homeowner was saying to me, can't we have the HOA approve who the tenants are going to be? And I said, no, you can't do that. The law is very clear. The governing documents are very clear. Homeowners have a right to rent their property. And I think the cap that they came up was meant as sort of a compromise. We know there are caps out there. Let's say caps can't go below this amount, but I agree with you, it causes other problems too. And the way housing is right now, my personal view is let's err on the side of making sure folks have a place to live. There's case law where the court is saying, it's sort of undisputed that when you have a lot of renters in a community, it causes problems because you have folks that aren't as invested in the community. And that's true, that's some potential issues there. By the same token, we know it's hard for folks to find places to live right now. Let's make it easier for them, but that's just me talking, that's not the law. You're absolutely right, there's a lot of complicated issues that go on there, changes in the law that you want to make sure your CC&Rs are up to date with. And the more you're doing something like having a rental cap, the more it becomes important that you either in the CC&Rs or in a policy clarify how this is going to work in real time. We've got the wait list, we've got folks not sure what they're going to do with their property. Is that fair to them? How are we going to deal with that? You need to have something clear in the governing documents that addresses that. That's a lot. I hope that was helpful to you.
A little bit, but like, are there associations that have a cap, and then how is that enforced? Who enforces that?
With great difficulty.
A board? Is it a lawyer? Who is it that does that?
The board is the one responsible for enforcing the governing.
I got transferred, like say I got transferred my job to Arizona, all of a sudden, I don't want to sell my house at some price. Who can make me sell my house if I can't rent it?
I've got a community where for, I think, a year and a half or more, I was helping them with this very issue. And what it was coming from was, to answer your question, the board is the one responsible for enforcing the governing documents. Our job is to guide them what they can and can't do. And we had basically a situation where the board was convinced that there were all kinds of folks in the community that were renting that weren't supposed to be renting, hadn't gotten proper approval. And we went through hearing after hearing after hearing where basically we're calling those folks in saying, we think you're renting your property in violation of the governing documents. What do you have to say about that? And sometimes it was a matter of, well, we think that based on something you posted online and you're saying, I'm not renting my property, you misunderstood what I posted. Sometimes it's situations where, like you're talking about, I had to move overseas and I'm now stuck overseas. I can't get back, I have to rent my property. And usually what you have is a hardship provision where technically the board is supposed to keep things at this level, but the board has the discretion to say, okay, in this situation, because of this gentleman's situation, we're gonna let him go ahead and rent even though it's technically above the cap.
It's pretty tough, especially we've seen large investment corporations purchasing homes that come for sale and then are immediately goes into a rental.
Oh yeah, and that's part of the goal of the cap is to keep that situation from. Yeah, sir, you've been very patient, go ahead.
Our rental restrictions are under the category of rules.
Mm-hmm.
And determines whether you put it in an operating rule or you have to put it into the CCNR?
I believe that particular law did say it has to be in the CCNRs. And don't hold me to that, but I think that particular situation, it did say this change has to be made in the CCNRs. I hope that helps. I saw a couple other hands over here. I want to get back to you, but I saw some other hands. Yes, ma'am.
I have a question, just because it's coming up at our board meeting tomorrow.
Mm-hmm.
We don't have an activities committee, but,
I want you to take the microphone.
oh. Yeah, we don't have an activities committee, but we want to start like a social event thing.
Mm-hmm.
Is it okay to allocate funds for social events if it's not in our governing documents? One of the board members thinks because it's not in our governing documents, we can't allocate a small portion.
The short answer is going to be, it depends, and I'd have to look at it. The basic idea with the budget is you're making sure you're doing what the HOA is required to do. You're putting together, sit down with and figure out a budget. Okay, next year we're going to have X amount in maintenance costs. We've got insurance premiums. We've got to pay management. We've got to pay legal. How much money do we need for that? Okay, that total divided by X number of homeowners, that's their assessments. And the more you sort of strictly adhere to what the governing documents say you have to do, the more solid footing you're on. And there's a part of the law that says, because the HOA is a nonprofit corporation, it can't take in more money than it needs to do the things it's required to do. So there might be some question there as to whether you could take on money, factor money into your budget for sort of social funds. There might be a way of doing it, particularly if you're talking about a relatively small amount of money over the course of the year. But I would want to have my office or some council look at it for you and make sure you're not getting yourselves into trouble there, because from a technical standpoint, it's not really what the law envisions, but I understand the appeal of wanting to do it, and there probably is a way of doing it. I want to get back to you. Yes, sir.
Just on the rental thing, again, when you have an owner that has, decided to rent their property knowing that they can't, or outside the cap.
Yeah.
And you send them a letter and all that kind of stuff. What's the actual recourse? What do you do? Because, you can't force them to sell. The fine's limited to $100.
Yep.
Per incident, so that's useless. What happens?
So I don't know if everybody heard the question. The question is, when somebody's renting and they're in violation of the governing documents, what can you actually do to address that? And like your question earlier, the short answer is it's complicated. And I've had situations now where, okay, we're not going to tell you to evict anybody because we don't want to interfere with your lease agreement. That's a contract between you, the homeowner, and your tenant. Our concern is you're in violation of the governing documents, and you need to figure out a way of addressing that. You need to remedy that in some fashion. The way we have to think about it is whatever's going on the homeowner's property, the homeowner is responsible for making sure their property is in compliance with the governing documents. So I'm not going to go to the tenant. I'm not going to call the tenant to a hearing. We don't have contractual privity with that tenant. We don't have a contract with that tenant. We have a contract with the homeowner, who has their own separate contract with the tenant. So what we might do is call that homeowner to a hearing and say, you've got a violation, or help us understand why you think it's not a violation, and then your responsibility as the homeowner is to address it. To your point about whether fines are sufficient to motivate them, it's always tricky because you don't really want to be in the position of putting pressure on somebody to evict somebody, but you also have the duty to make sure they're in compliance with the governing documents, and how you're doing that is tricky. It raises a lot of problems.
Fine, what's the next step?
Part of the answer to that is, and again, might be another reason to amend the governing documents, is whether a reimbursement assessment is a possibility. So some governing documents, the law says if a homeowner causes damage to the common area property or somebody else's property, you can impose an assessment against that homeowner to make them reimburse whoever it is for that cost. Some governing documents, although not all of them, say you can do the same thing if a homeowner's violations cause the HOA to incur costs. So somebody's renting their property, the HOA has to get counsel involved, has to get excess management fees to do a bunch of hearings with this person. Along the way, the HOA is incurring thousands of dollars in legal fees and excess management fees. You hold a hearing where you're saying, okay, you're in violation. We're not going to tell you what to do with your property, but you're in violation, so we're going to impose this reimbursement assessment for the costs you caused us to incur and expect you to pay that. And that sometimes can serve as a motivation for the homeowner to figure out their situation. I'm not going to tell somebody to evict somebody because the tenant has their legal rights. And I want that homeowner to retain counsel of their own to figure out the proper way of respecting that tenant's rights. But I will say you need to cure the violation. and here's our way of motivating you to cure the violation, this reimbursement assessment, and hopefully that, gets you to sit up and take notice and fix the problem. But anytime you're dealing with homeowners who are renting, it's a complicated balance of issues that you've got to address, and you're right about the fines, making it a little challenging. There might be issues sometimes. Part of what AB 130 says about fines is that you can impose higher fines, higher than $100 if you're talking about safety or health issues. I've had situations where what's going on is, well, it turns out there's sort of a drug haven going on here, and actual crimes occurring on that property on a regular basis. That might be a situation where we can impose a higher fine. There might be other reasons as well. But the short answer is to work with counsel on, particularly with the complicated rights involved. You always want to work with counsel on dealing with these situations, and also dealing with, okay, what are the actual tools we have to try to motivate this person to fix their violation? I hope that helps.
Yeah, because there's no damage to the HOA.
Yeah.
It's just the other people that have been patiently waiting for years
Yep.
in line to rent their property.
Yeah.
That's the real.
And the flip side of that might be, and again, you want to work with counsel. It depends on the circumstances. There might be situations where you say, okay, we're over our cap because this one person is renting and they're not supposed to be renting. I wouldn't count that as part of the cap anyway. I would say this is somebody who's in violation. Meanwhile, you're waiting in line to rent your property, and if we don't count that person who's doing it in violation, we're not at the cap, so you get to rent your property. And now we're at the cap again, and it's legitimate. That makes sense? Yes, ma'am.
So I just wanted to say something to that activities
Mhm.
committee thing. We're a not-for-profit mutual benefit corp.
Yep.
Do the not-for-profit rules for gambling apply when, like, you have a social committee or an activities committee that wants to play
On-site Texas Hold'em.
on-site gambling games, and they want to take the money and use it for social activities, and it's not getting turned in through the accounting process.
Mhm.
I see all kinds of issues there potentially, but I don't know. That's
Part of what we're wandering into tax issues somewhat now. I would go back to what I said a moment ago. Technically, the only way the HOA is supposed to bring in money is through assessments, and it's supposed to only be the amount of money the HOA needs to actually function. So anytime a client comes to me and says, well, Lance, we want to hold a bake sale to bring in a little extra money to have some fun, have a pizza party, it sounds harmless, but I get nervous about that because, yeah, you're wandering away from your role as an entity and what you're supposed to be doing, and it's something that opens the door for the potential for corruption. I had a situation not long ago where they had on-site laundromats. The HOA was technically responsible for the coins going into the machine, and one of the board members had decided a few years prior that he was going to handle that money directly. And I won't get into the details, but that's it raises the risk of corruption, and you don't want anything that even looks like the risk of corruption. So again, I think talk to counsel about that, and we're happy to help out. But there might be a way of doing it, but my initial gut reaction is that from a technical standpoint, you probably can't. So you want to work with counsel to figure out if there's a way around it. But thank you very much. Were there other hands up? Everyone tired of me talking?
Yeah.
Yes, sir.
Do you comment on the new fining law, like the fines in the system? Because as we all know, that's like the main thing
Yep.
that we can utilize to get compliance. Is fines that finally get thousands and thousands of dollars.
Yep.
A $25 fine, people are like, I'm just gonna keep doing it. Nobody cares.
Yep.
So like, for a while there, we were able to like get fines of a few thousand dollars, and then that's the only way we would ever get compliance on anything.
Yeah.
And so, but now that I understand that's changed, can you just speak to that?
Yeah, so what we're talking about is AB 130. This is a new law that took effect right at the end of June of this year with really no warning. It wasn't supposed to pass. There were no committee hearings. There was no opportunity for public comment. It was folded into an omnibus housing bill, and just literally overnight, HOA suddenly had a cap on how they could impose fines. But it also changed the disciplinary hearing procedure, and I don't have all my notes with me to explain the ways it changed, but you need to work with counsel anytime you're calling somebody to a hearing, because it changed the way that you hold a hearing when you're calling somebody for enforcement issues in the first place. But what it said was you can't impose a fine of higher than $100 for violations of the governing documents. It also said you can exceed that for health and safety issues, But there's a couple of tricks to that too, because you have to now update not only your fine schedule, but your enforcement policy to say, what's the fine going to be if we're talking about a health and safety issue? Are we talking about $3,000? Are we talking about $500? What's it going to be? We're working on sort of a list of things that might fall under that heading, and it turns out it can apply to a lot of things, violations that, yeah, they actually do raise a health issue, they do raise a safety issue, and that gives you some wiggle room to deal with those issues. But yeah, it creates that cap, it has the exception for health and safety issues. It does essentially require that you adopt a new fine schedule, that you adopt a new enforcement policy to reflect the change in the law, and it can be very frustrating for boards. I think again, the motivation seems to be we don't want to make it harder for people to live in an HOA, which I think this is a very sort of things that make it hard for people to buy housing in an HOA. I think the fines aren't the main issue. I think it's sort of a roundabout way of getting there. But that's the theory, is we don't want people to be saddled with no warning with a bunch of fines they couldn't anticipate. So I've got a client right now where they have fines where for the first offense it'll be $2,000. That's the type of thing the legislature's, I think, most concerned with, and making sure that you're not hitting people with these huge exorbitant amounts. But what you end up with is, in theory, any violation is $100. You have the exception for health and safety issues. The other wrinkle to this is, how do we deal with something that is a repeated issue? How do we deal with something that's an ongoing issue? So if I park my car in the wrong place on Tuesday, and then again the following Wednesday, and again the following Friday, those are 3 distinct violations. And as the HOA's counsel, I'll say, okay, that guy gets $100 for each time that he did that. If I'm failing to mow my grass, though, for months on end, is that one violation? Is it multiple violations? The legislature, the courts probably aren't going to look favorably on sort of a daily fine. You get $100 for each day that you didn't cut your grass. What we're saying right now, and again, this is a work in progress.
Okay, the daily thing?
I think no. I think the legislature wouldn't look favorably on doing a daily $100 fine. I think that's the type of thing they're trying to avoid. So what we're thinking right now is call that person to a hearing once a month, do the most you can, and keep calling them once a month until it gets done. I don't know, everybody's sort of hoping that the legislature is going to fix this. But the bad news there is that if they do fix it, it's going to be probably no sooner than January 1st of 2027. We have to get through another legislative session. There's nothing left is going to happen this session. The session's over. So we're talking about 2026, the legislature considering a law that then probably wouldn't take effect until January of the following year. So we do have to live with this for the time being. But like I was saying to the fellow over here, work with counsel on ways of dealing with the particular situation in front of you. And is this one where we can justify a higher fine because it is a health and safety issue? Is it one where our governing documents allow us to impose a reimbursement assessment because we're racking up a bunch of cost and dealing with the violation? Are there other tools we can use? You can still cut off people's access to the common area amenities. You don't get to use the golf course anymore. You don't get to use the tennis courts anymore. You don't get to use the pool anymore because of your violations. That's still fair game. It's been the case for a few years. You cannot prevent somebody from voting anymore. That used to be a sanction you could use. You can't do that anymore. I think the short answer, though, is work with your counsel to make sure you've got an up-to-date fine schedule and enforcement policy that deals with the new procedure, because the hearing itself has changed. But also, when you have situations where, gee, we'd really like to throw the book at this guy for his violations, work with counsel on what tools you might have in that particular set of circumstances. I hope that helps. Yes, sir.
Getting back to health and safety.
Mm-hmm.
We've had a tenant, we've found them before, they are not somehow signed up for trash service, which is mandatory in the county.
Mm-hmm.
Trash bags get dumped through their fence.
Hmm.
And it'll be 1, 2, 3, then all of a sudden there's 30, 40 trash bags.
Okay.
So that is a health and safety, because you're really not gonna open a trash bag, find out what's inside.
Yeah, I wouldn't want to.
But, so how does our policy change to finding the process of finding the person?
I'll give it the caveat of I would want to look at the specific circumstances, but based on what you're telling me right now, I mean, what you have to do before you can even do the higher fines is you have to change your fine schedule. If it's not in your fine schedule, if it's not in your enforcement policy, you don't have the ability to do it. I don't care what the law says. So you need to change your policy to say, X and Y and Z violations or these types of violations, we're going to impose a fine up to $500 or $1,000, whatever you think your community needs. Get that in place. And then call not the tenant, but call the homeowner to a hearing and say, okay, we're going to impose these fines. We've got photos showing 30 bags over the fence coming from your property, we're going to impose, arguably, you might consider a fine for each individual bag. But again, you want to work with counsel and make sure, and I'm happy to look at the details for you, but to make sure that you're not wandering too far afield with that.
Right now, we're sending a letter out, fining $100,
Mhm.
plus the cost of cleaning if they don't remove it in 10 days.
Okay?
Okay, so we're in our legal rights to hire an outside service, get it up, it's considered hazardous waste, and then send the bill to them too.
Make sure you're calling the person to an actual hearing. You can't just send a letter and impose those things. You have to call them to a hearing, give them a chance to respond, and then as a result of that hearing, issue the notice of discipline saying, okay, we're now imposing this fine, we're going to make you pay for, ideally, you're going to have something supporting what the costs are going to be, a bid or something along those lines that you're attaching to that notice of discipline. We're now imposing this fine, we're now imposing this reimbursement assessment for the cost we're going to incur because you didn't clean it up.
So if you give 10 days notice, how much time do you respond?
You have to give them 15 days notice for, 10 days notice for the hearing. You have to actually send out a notice of the hearing, call them to a hearing, give them a chance to respond. If they don't show up, that's up to them. But you have to give them at least 10 days notice for the hearing. Some bylaws say 15 days, but at least 10 days notice for the hearing. They show up at the hearing, and then within 15 days of the hearing, you issue the notice saying, okay, here's what we decided now. Here's what you're going to have to pay. So, yeah. Other questions, comments, concerns? Yes, sir.
When you restrict an owner's use to, amenities of the property,
Mhm.
can you also restrict tenants?
Yeah, I mean, the idea of a tenant is that the homeowner, depends on the wording of your governing documents, but usually what it is the homeowner has a right to use the amenities, and they transfer that to their tenant. What you're saying is, homeowner, you've now lost your right to use those amenities, so there's nothing for you to transfer to your tenant anymore. It doesn't exist anymore. So again, you're not interacting with the tenant directly. You're saying to the homeowner, you don't have this right anymore, and you probably want to tell your tenant that.